Good morning, everyone. And we were discussing Constitution. I think almost all the chapters, including the important constitutional amendments, we had discussed already. Okay. Only one topic is left. That is the landmark cases law. Landmark case laws that are given by the Apex Code, and those are sometimes asked. So we will try and study them one by one. Okay. Uh, yes. Landmark case laws. Okay. So now the first one that we will discuss today is the Ayodhya dispute case. Ayodhya dispute case. Does anyone know the name of the Ayodhya dispute case? Anyone? Hmm? Everyone knows that like Ayodhya dispute case only. It is M. Siddiq D. LRS versus Mahant Suresh Das and others. 2019 Supreme Court cases online 1440. M. Siddiqui THRLRS versus Suresh Das and others. Now, this was basically, if I tell you the facts, what happened in this case was there was a group, I mean, between Hindu and Muslims. Hindu and Muslims, there was a dispute concerning a piece of land, concerning a piece of land measuring 1500 square yards in the town of Ayodhya. In town Ayodhya. Okay. So if we really see, this is nothing but a land dispute case. Of course, that was between two groups, but nevertheless, it was a land dispute case. Hindu people, what did they say? It said that it is the birthplace of Lord Ram, okay, incarnation of Vishnu. Hindu people claim that particular piece of land, which I told you was measuring about 1500 square yards. Hindu claimed that it was the birthplace of Ram, whereas the Muslims claim that it is the historic site of Babri Masjid, built by Babur. Babur was the Babur was whom? He was the first Mughal emperor. Okay, so concerning that piece of land, which Hindus claimed as the birthplace of Lord Ram and Muslims claimed as the site of Babri Masjid, there was this land dispute. Okay, now there was a five-judge bench. The hearing continued for a long time. Five-judge bench headed by CJI R. Gogoi. Okay, it was almost more than 100-year-old dispute, by the way. More than 100-year-old dispute. This was put to rest by delivering the judgment in favor of, you can say, They tried to do a balance, but it was almost in favor of the Hindus. What happened? So the judgment, if we really have to see, the key takeaways are granted entire 2.77 acres of disputed land, whichever the land, the 1500 square acres or 2.77 acres disputed land, to Ayodhya. Ayodhya, and especially in favor of Ram Lalla. Okay, in favor of God, Ram Lalla, it was given. Very controversial judgment. I really don't like it, but I'm just telling you what happened. Okay, and then directed government, that is both central and UP, both to allocate 5 acres of alternate land, to Muslims in a prominent location, to build a masjid, to build a mosque. Okay, so that land was given to the Hindus, and especially in favor of Ram Lalla, and directed central and UP government to allocate a prominent location, alternate piece of land of 5 acres. Okay, so consolation prize was given. Okay, and there it was also, the central government was also directed to create a trust within 3 months for construction of Ram temple on the disputed site where Babri Masjid was demolished in 1992. So basically, the fact remains that we all have seen, or there are direct evidence suggesting that Babri Masjid, which was there, was demolished in 1992. But of course, the allegations of Hindu were that Babri Masjid was built on the site, demolishing a Ram temple which was earlier there. Okay, I don't know. Without any evidence, the it was ordered that uh, Babri Masjid was illegally built, and it was believed that Ram was actually born there, and somehow Supreme Court ventured into the civil dispute, certain religious aspects, and gave this judgment of Lord Ram and Hindus. Okay, and there was a intervener who is the third party. Now they were also claiming certain rights. Third party was actually Nirmohi Akhara. They were claiming certain rights as well, and central government was asked, in fact, not ordered, asked to consider the representation of Nirmohi Akhara to set up a trust. Okay, so that was also done. Intervener, third party Nirmohi Akhara, some sort of uh, help was also done, and Supreme Court declared that 1992 demolition of 16th century Babri Masjid was a violation of law. Now, if we was a violation of order, violation of law. So, if we ordered that it is a violation of law and Babri Masjid was actually there from 16th century and it was demolished, then why was it not allotted a piece of land there or some sort of consolidation was not done? Still remains a mystery, and we would like to refrain from making any comments on that. Just the facts and whatever was the judgment I told you. Okay, so entire land was given to Ram Lalla, 5 acres alternate piece of land at a prominent location. Central government to set up a trust to create to build Ram temple within in that disputed site. Nirmohi Akhada, that was also given some sort of relief by asking the central government to consider the representation made. And while all doing all this, Supreme Court declared that the demolition was illegal and it was a violation of law. Okay, doesn't make any sense really. Next, so this is the first judgment that we studied. That is the Ayodhya dispute case. Where now next, adultery decriminalized. Adultery decriminalized. That was through the famous judgment Joseph Trine versus Union of India. That is AIR 2018 Supreme Court 4898. Okay, this was, of course, the facts were whether adultery is a crime or not, and that was challenged. That was challenged, and CJI Deepak Mishra, this 158-year-old section, 150-year-old section of 497 of IPC, okay, which was holding adultery as a crime. So Deepak Mishra held that, Justice Deepak Mishra held that adultery is no longer a crime, but will continue to be a ground for divorce. It's no longer a crime, but it will continue to be a right of, ground of divorce. Okay. Now, CJ Deepak Mishra, I told you how he loves wordplay and how he loves using fancy words. So his observation was, you may write this: any provision of law affecting individual dignity and equality of women invites a wrath of constitution. Serious wrath of constitution. Okay, and it was also said it's time to say that husband is not the master of wife. Legal sovereignty of one sex over the other is wrong. Is wrong. Hence, Section 497 is manifestly arbitrary. Okay, so it says that if you do anything which is of any provision of law which is affecting the individual dignity and equality of women, it invites the wrath of the Constitution. Wrath as in the uh, what do you call it? The anger of Constitution, or the destruction that Constitution will unleash. And it's time to say that husband is not the master of wife. Legal sovereignty of one sex over the other is wrong. Hence, 497 is manifestly arbitrary. Now, having said that, I just want to ask, how many people think that this is a good step? Can you all raise your hand? Whoever thinks it's a good step? Just one? Sushant, just one? Everyone else thinks it's a bad step. Sri, Vishaka, 3, 4, Yatna thinks also. Okay. Whoever thinks it's not a good judgment or wants to disagree. Okay, Anrup also thinks it's a good step. Anybody wants to disagree with this judgment saying that it's a bad step? Anyone? No one. I disagree with it, by the way. I think that instead of decriminalizing it, if you would have punished it from both the sides, that would have been the nicest thing to do. See, it was there as an offense against marriage, and for a reason, so that there should be monogamy promoted. So, taking into the culture and fabric of the Indian society, that provision was there. Now, if we could have simply said that adultery can be prosecuted by husband and it can also be prosecuted by the wife, it would have been it would have been it. Both could have done that. That would have probably answered your arbitrariness or husband is not the master of wife. We are not saying that. We will say that each partner has a right to prosecute when there is an adultery committed by the other partner. Okay, that would have solved the purpose. But instead, this was decriminalized. But anyway, uh, we are who are we when Supreme Court says that the wrath of the Constitution is unleashed? Okay. Now, 497 is unconstitutional, so no longer a crime. But imagine somebody commits adultery. Imagine X is there, and now adultery is X and Y are married. Now Y and Z, they commit adultery. Now for the same, X commits suicide. Even though adultery is not a crime. But if for the same someone commits suicide, it can be held as abetment of suicide. That this was also given in this judgment. Okay, so that means adultery is not criminalized, but somebody is dying or committing suicide because of the adultery that you did, then this will be an abetment of suicide. That's what it says. Okay. Next case. Uh, I'm also citing some recent judgments also. I mean, that's why this Ayodhya disputes and all I'm disclosing as well. Next, Sabrimala temple case. Sabrimala temple case. Now, what happened? This the judgments. If we have to see the citation, it is Indian Young Lawyers Association versus State of Kerala, 2019. 11 Supreme Court cases, 1. Indian Young Lawyers Association versus State of Kerala. Okay. Now here there was a ban on entry of women aged between 10 to 50 from entering Sabrimala temple. The facts were that there was a ban on entry of women aged between 10 to 50 from entering Sabrimala temple. Now, the ground only given was that they are menstruating. They are menstruating, they might be menstruating. So, from the start of menstruation till menopause, uh, anyone that is 10 to 50 normally, they will be banned from entry. Okay. Now, this was challenged. This was challenged in the Honorable Supreme Court, saying that it violated many articles of Constitution, many fundamental rights were violated. Okay. Now, a bench headed by same CJI Deepak Mishra. Okay. Many other judges were there, Rohinton Nariman, and there was also Y. Chandrachud. Okay. But Indu Malhotra was there. Justice Indu Malhotra was also there, who dissented from this. Okay. Will not really know the names who were there, but yes, many people were there, and it was actually the ban was removed the ban which was put removed the ban which was put. Okay. So that's how women of all ages women of all ages were allowed to enter Sabrimala temple. Now, see, the irony is only dissenting opinion was by whom? I told you, no? Who tell me? Dissenting opinion who gave?
Hindu Malhotra.
This is Indu Malhotra, who was a woman herself. She said that yes, they say good ground for ban. They shouldn't be allowed. Okay. Now, yes. Now, in fact, it is again challenged in another case, that is uh, Raji Varu, Raji Rajivaru versus Indian Young Lawyers Association and others. This has been challenged, and now also the the judgment is it has been referred to a five-judge bench, and judgment is still not out. Okay, regarding that, it's still not out, but yes, the ban was lifted by this particular case. Okay, so it said, so CJ Deepak Mishra's statement regarding this was devotion cannot be subjected to gender discrimination. Devotion cannot be subjected to gender discrimination. Clear? Next, we'll have to be quick. We have a lot of cases by the way. Let's see how many we can do today. Okay, now section 377. Now it was partly struck down, not wholly, partly struck down, and the case is that of Navtej Singh Johar versus Union of India through Secretary of Minister of Law and Justice. It is the AIR 2018 Supreme Court 4321. Okay. Now here, what was decriminalized? Consensual homosexual acts between adults was decriminalized. Decriminalized. Okay. Now, Justice Deepak Mishra, he was also again in the helm of affairs. Okay. And it says that it is violative of fundamental right of privacy. Okay. But why do I say it is partly struck down? Because unnatural sex with animal, animals and children still continue to be an offense by the way. It's not like it's completely gone. Still continue to be an offense. Just that part where two consensual adults are indulging in any sexual acts, even though there are homosexual in nature, that is of same sex, homosexual as in same sex, still then it would not be a crime. Okay. Another case, live streaming of court proceedings. Live streaming of court proceedings, if we really see, this is also this is also uh, the brainchild of Deepak Mishra. Justice Deepak Mishra, he was for a long tenure, so made a made very many judgments in that regard. So Sapir Tripathi versus Supreme Court of India, which is 2018. Okay, so ordered live streaming and video recording of court proceedings. Okay, the line that was quoted by him is something like this: sunlight is the best disinfectant. Sunlight is the best disinfectant. Okay, so if it is hidden, that means it is infected. But if there is sunlight on something, then it's not infected. So, citing that, this was done. Next, Aadhaar bill and right to privacy. Aadhaar bill and right to privacy. This was Justice K.S. Puttuswamy versus Union of India 2018, one Supreme Court cases 809. Okay. Now here the Aadhaar was Aadhaar bill was challenged where uh, uh, the banks and telecom companies were asked to link their bank accounts with mobile numbers with Aadhaar. So the entire Aadhaar bill was challenged by the Justice K. S. Puttaswamy, who was in fact because he passed away recently. He was a social servant and used to he challenged it. And here it was held it was held to be it was held to be constitutional constitutional but with certain conditions. So it said that right to privacy cannot be interfered interfered when except when reasonable restrictions are to be put in interest of state or society. So, one hand, it was said that yes, right to privacy is there; it cannot be interfered. On the other hand, it was said that yes, if if certain restrictions are put, that can be put by the state, and then when it is put, then it the right is not existing anymore. Okay. Now, whenever I'm discussing, just know that you have to go and read the judgments also. Full judgments you try to read. Otherwise, you'll not get never get a clear picture. I'm just telling you the summary, but you should. That's the reason I'm telling you the citations for you to go back and read the entire case. Okay, so the task would be to read the entire cases, all the cases that we are discussing today. You will have to read them all. Right to die with dignity. This is Common Cause versus Union of India. Common Cause versus Union of India, which is AIR 2018, Supreme Court 1665, where legal sanction to passive euthanasia. Passive euthanasia was given. What is passive euthanasia? Basically, if if certain patients are on medical support, but in irreversible coma, they are on medical support but in irreversible coma. That means the moment that medical support is withdrawn, suppose there are some person is on ventilator but in a coma, and as soon as that ventilator is switched off, he will die. And ventilator takes to keep it maintained, it takes 50,000 a day. Not only that, but also he's suffering throughout because if it is irreversible coma, that means there is no chance of him waking up. So in such a case, Supreme Court said that such medical support can be withdrawn. Can be withdrawn to give a death with dignity to the terminally ill patients. Terminally ill patients who are suffering from cancer or some other disease who are uh, done, that is can be done, and it was also permitted for making of a living will. Living will as in while I am living I can make a will saying that if I am in such a condition, my life support may be withdrawn. My life support may be withdrawn. So Supreme Court allowed this concept of living will here. Okay. Uh, so yes, it was a good welcome judgment. Next, triple talaq. Triple talaq. Saira Bano versus Union of India. Saira Bano versus Union of India, which is 2017 9 Supreme Court cases 1. Okay. Now here Supreme Court held that triple talaq is unconstitutional. Okay. Triple talaq is unconstitutional. In fact, the instant triple talaq was what considered. So at once, if you're mentioning talaq, 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 and divorcing the wife, it was held that it was violative of Article 14. Okay, and it was also held that triple talaq, instant triple talaq, instant triple talaq goes against Sharia and basic tenets of Quran. Goes against Sharia and basic tenets of Quran. Goes against that. Okay. Now, sudden provocation, rage, or whims, never on those grounds. Previously, what used to happen that somebody will be drunk, the man will be drunk, coming home, and of course, consuming alcohol is haram anyway in uh, Islam. But still, those people who drink and come back home and say talak, talak, talak to the wife, and later on in the morning, even if they reconcile, saying that no, no, I did not want to divorce you, the divorce is already done. Okay, because there was pronouncement of three talaks and the neighbors heard or something happened. Okay, so that's why this was held unconstitutional, derogatory, and it was also held derogatory and discriminatory for women. Okay, because it is as if the woman is an object that you can throw whenever you want just by mentioning talak thrice. Okay, so remember that it is only applicable to talak, instant talak, that is talak e biddat, but not in talak e sunnat, talak ul sunnat. Okay, it is not applicable to talak ul sunnat. So here the difference is here there is no waiting period. Just mention that and that is done. But here during iddat it can be revoked also. It can be revoked also. We'll study all of that when we study the Muslim law, of course. Okay. Okay. Now, uh, yes. In fact, Muslim Women Protection of Rights of Marriage Act was made on this. You're right. On this, there was a act, that is Muslim Women Protection of Rights of Marriage Act 2019. The silent features were that if somebody is doing this triple talaq and all of that, then it is punishable. It was held punishable. The act of triple talaq was punishable with a punishment of 3 years and fine, triable by JMSC, triable by Judicial Magistrate First Class, and it is a cognizable and non-bailable. Cognizable and non-bailable, offense, but compoundable offense. Okay, and here other things were there for providing subsistence allowance, subsistence allowance, custody of children, custody of children with women, with the woman, and no bail until the woman is heard. These were the silent features which came after this uh, this particular triple talaq that has happened with the woman. Okay. Now another case is that of is that of it was the case of awaiting death cases. Awaiting death cases. Now what happened is there was a case filed by Ajay Kumar Pal versus Union of India, which is a 2015 two Supreme Court cases 478. Okay, it said that the person was challenged. This person was convicted and was sentenced to death. Death punishment was given. Now he had filed a mercy petition before whom? Before the president. Now he had to wait for 3 years and 10 months. Huh? And still 3 years, and after 10 months, 3 years and 10 months, it was communicated that your mercy petition was rejected. It is rejected. Now, this petitioner argued that this is nothing but mental torture, mental torment, and this inordinate delay. And that's why I was kept in solitary confinement from the death of, because after death sentence is awarded till the execution, you are kept in solitary confinement. So, due to all this delay, he stayed in solitary confinement for almost 4 years. Okay. Now, that's why here it was challenged that uh, it should be commuted. It should be commuted, and in fact, Supreme Court commuted this, commuted death to life imprisonment, citing this reason that the torture, the mental torment that you have inflicted by delaying this disposal of mercy petition, uh, the mental torment that you have done by putting him in solitary confinement. That's why it was, in fact, said that it should be commuted to life imprisonment. Okay, so it said that yes, it is a ground to commute the death to life imprisonment where there is delay in disposal of mercy petitions. Now, recently, so I think few days back, NALSA has also filed a PIL seeking removal of all the terminally ill patients who are suffering in jail. So basically, who are destined to die, who are terminally ill, and they will die very soon. And those people who are stuck in any jail, for release of them, there is a PIL file. Now, Supreme Court is to hear it. So let's see what happens. Okay. Then national anthem case. National anthem case. Sham Narayan Choksi versus Union of India AIR 2018 Supreme Court 357. Here again, it said that playing of national anthems national anthems by movie hall is directory and not mandatory. So that means not that everywhere it has to be played. Because in a rule, uh, in an order issued, it was actually there was a provision changed and it was mentioned that in every cinema hall the national anthem has to be played. Now San Ryan Choksi challenged it and Supreme Court held that it is not mandatory but directory. But it said that if cinema hall plays it, then compulsory for every person to stand in respect, except if disabled and hence exempted. If they are disabled, then they are exempted. Of course, disabled people will not have to stand. But other than that, if there is anyone else and in the cinema hall the national anthem is played, then everyone has to stand. Okay. Next, collegium system. Collegium system, which is collegium system case, which is the Supreme Court AOR, Supreme Court AOR Association versus Union of India 2016, 5 Supreme Court cases won. Okay. Here it said that independence of judiciary is basic feature, and I'd discussed this, I think. Basic feature and hence NJAC that was done, NJAC National Judicial Appointments Commission, it prescribed how judges are to be appointed. That was ultra virus. Did we discuss this or not? Tell me. Huh? Anyone who attended constitution classes, I think we discussed this. Yes or no? Previously, while discussing the judiciary. अरे हाँ या ना बोलो. କଣ କରିଥିଲେ ନା କରିନଥିଲେ?
Yes, sir.
ଓକେ, ବାକି ସବୁ ପାଟିରେ ବ୍ୟଙ୍ଗ ପ୍ରଶ୍ନ। ସାରଲା ମୁଦଗଲ କେସ୍। ନେକ୍ସଟ ହଉଛି ସାରଲା ମୁଦଗଲ କେସ୍, which is the Uniform Civil Code or Uniform Civil Code case ତାକୁ କହିପାରିବା. This is Sarla Mudgal versus Union of India 1995 Supreme Court. Sorry, AIR 1995 Supreme Court 1531. Okay. Okay. Now here Uniform Civil Code is the need of the hour. Uniform Civil Code is the need of the hour that was held by uh, uh, the Supreme Court, where in fact there were two petitioners who challenged. Okay, so what happened here that there was a woman named Meena Mathur. I'm telling you the facts. Meena Mathur, and he was married to Jitendra Mathur. Now, without giving divorce to the first wife, uh, just to marry the second woman, he converted to Muslim religion. Okay, and later on, he again abandoned the second wife and went to the first wife. Okay, now here the second wife filed a writ that regarding maintenance and uh, maintenance as well as I think the legitimacy of the child born out of that wedlock. Okay, now they said that they questioned this, that if somebody can actually do this, then what is the need of religion altogether? Okay, so uh, that is the reason this Uniform Civil Code was questioned, and there Supreme Court discussed many things, including the need of the Uniform Civil Code uh, in the whole of India, irrespective of the religion. Irrespective of the religion. Okay. Next, EWS quota. EWS quota. Okay. Now, 103rd constitutional amendment allows 10% reservation, 10% reservation for economically weaker section. Okay. Now this was challenged that this 10% reservation is not is breaching the 50% cap, which is fixed by the Indira Shani case, because Indira Shani case said that limit of reservation is 50%. Limit is 50%. Okay. Now it said that 10% can be granted. Supreme Court said that 10% can be granted, but should not exceed 50%. But should not exceed 50%. Okay, so in no case reservation can exceed 50%. Next, flag hosting case. Flag hosting case, which is Union of India versus Nabin Jindal. Union of India versus Nabin Jindal, AIR 2004, Supreme Court 1559. Flag hosting case. Okay. Now, Navin Jindal, who was trying to fly a national flag in his official building, he was prohibited by the government official as per the Flag Code of India. And here he moved to the Supreme Court saying that he has a right to fly the national flag. Okay, and that's a fundamental right. Uh, it was questioned and it was but the central government said that it can restrict the use of national flag at any place or building under section 3 of the Emblems Act. Okay, now apex court ordered that it is our national pride and it is a freedom of expression guaranteed under article 19(1)(a). Okay, so national flag. So what was held by Supreme Court, that national flag flying of national flag is symbol of freedom of expression guaranteed under article 19(1)(a), flag hosting case. Okay, next, now change of words in national anthem. Here, this case is of the year 2005, which is Sanjeev Bhatnagar versus Union of India, AIR 2005, Supreme Court 2841. What happened here is that there is a word Sindh, no, in the national anthem, and it was said that because Sindh is now Pakistan, that's why it should be changed. Supreme Court held that words used in national anthem should be changed. National anthem can be changed. Can be changed. As it is a literary creation. It's a literary creation, so it should be honored. It can't be changed. Okay. Next, right to marry a person. Yes, Chetna, tell me.
Sir, I think by mistake you have written can be changed instead of can't.
Oh, words used in national anthem can't be changed. Correct. Thank you. A right to marry a person of one's choice. This is popularly known as the Hadia case. The citation is Safin Jahan versus Ashokan KM, AIR 2018, Supreme Court 1933. Okay, here what happened? There was a girl, uh, which is Hadia. Her name was Hadia, alias Akhila, who was from Kerala, and she was converted to Muslim religion, and then she married a Muslim person named Safin Jahan. Okay. Now, Hadia's father filed the petition alleging that she was the victim of love jihad and she was brainwashed, and that's why this was challenged. Okay. Now, Supreme Court said that Hadia is 24 years old and she has the right to make decisions about her life on her own. And so, right to marry a person of one's choice is integral to Article 21. It was held that Article 21 covers a right to marry a person of his or her choice. Okay, that's in Article 21. Okay, next, highway liquor ban. Highway liquor ban, which is State of Tamil Nadu versus K. Balu, 2017, two Supreme Court cases, 281. So here, within 500 meters from highway, no liquor to be sold. Why? Because consuming liquor and driving at high speed uh, the creates many accidents, and that's why it was in fact said that this shouldn't be done. Okay. Next, legal assistance. Husainara Khatun versus State of Bihar. State of Bihar. It said that a a person should have legal assistance available to him or her if put in custody. If he is arrested and put in custody, he will have legal assistance, right? And that is guaranteed by Article 14, Article 21, and DPSP Article 39A. Both make sure, all three make sure that state has an obligation to give a lawyer at the cost of it to a person. Okay. Next, handcuffing. Handcuffing. Prem Shankar Shukla. Prem Shankar Shukla versus Delhi administration. AIR 1980 Supreme Court 1535. Okay, here Supreme Court declared that handcuffing is inhuman, unreasonable, and arbitrary. Okay, only when there is no way to prevent escape, then only handcuffing may be resorted to. Okay, so don't handcuff always. Only in exceptional cases you'll do that. Okay. Next, now there are many cases which is dealing with clean environment. So we'll try to consolidate them in one part. Clean environment. One is MC Mehta versus Kamal Nath. MC Mehta versus Kamal Nath, 1997. One Supreme Court cases 388. Okay. It said that it propounded public trust doctrine. Public trust doctrine, what does it mean? It says that natural resources are for general use, like air, sea, water, they are for general use and they can't be restricted to private ownership. These are gifts of nature and state is the trustee. So basically, it says that they are gifts of nature and state is the trustee of natural resources. Okay, so it is the duty of state to protect it. Protect it. Okay. Now, from these two principles were evolved. One is precautionary principle. Precautionary principle. It says that not to degrade environment. You should not do anything to degrade the environment, which is have some precaution. And there was polluters pay principle. That means you should not degrade, but if you have polluted, but if one has polluted, he has to restore the ecological balance. Ecological balance. Okay. So that means at the pollution that you did, you have to make sure that you plant trees or do something in order to restore the ecological balance. Okay. Now, same MC Mehta versus Union of India, but this is of 1997, where Taj Mahal, when it turned yellow, and there Supreme Court issued directions for protection of Taj Mahal, protection of this national monument. Okay, because of the environment, it was turning yellow. So that's why certain directions were issued. Okay. Now, another important case is Murli S. Deora. Murli S. Deora versus Union of India, which is AIR 2002 Supreme Court 40, where smoking in public places was prohibited. Public places was prohibited. Okay. This we may write as 21 Taj Mahal case. This is 22 smoking case. Okay. Next. 23 right to education. Right to education, which was inserted through the RTE Act 2002. That is, the case is Mohini Jain versus State of Karnataka. AIR 1992 Supreme Court 1858. Okay. So here it said that right to education is a part of right to life. Because there it was a part of right to life, because right to life does not mean only mere animal-like existence. So you have to have a life with dignity, and that's why this was held. Now, Sexual harassment case. Sexual harassment at workplace case. Workplace case, which is Vishakha versus State of Rajasthan. Vishakha versus State of Rajasthan, which is AIR 1997 Supreme Court 3011. It said that sexual harassment at workplace is a violation of Article 15 and 21 of Constitution. Okay, so it was detailed guidelines were issued how legislation should be made on this subject, and incorporating those guidelines, the act, that is sexual harassment of women at workplace, prevention, prohibition, and redressal Act 2013 came into force. Okay, so the judgment was given in 1997. Almost 15, 16 years after that, this act addressed that. Okay, sexual harassment at workplace case, Vishakha versus State of Rajasthan. Next, solitary confinement. Yes, it is the case of Sunil Batra versus Delhi administration. Sunil Batra versus Delhi administration. That is AIR 1980 Supreme Court 1579. Okay. Now here it was held that this solitary confinement, it violates Article 21. Okay. Violates Article 21, it was held. Okay. Now, telephone tapping. Telephone tapping. Telephone tapping case. This was also with respect to right to privacy, that it violates right to privacy. The case name is People's Union of Civil Liberties versus Union of India. That is AIR 1997 Supreme Court 568. Okay, here it was held that to hold a conversation through phone, that's a private thing, and somebody, if he's tapping, state cannot tap at its discretion. Okay, certain it has to be a reasoned order, and that too only on certain specified grounds. It's not like always. Okay, always it will be done. So order from the central government has to be brought, and it will remain in force for a certain day, that is certain period, that is normally for 2 months. It can be extended till 6 months, and then only it can be tapped. Okay, so order from central or state government to be obtained before telephone tapping. Telephone tapping. Okay. So next is law against female feticide. Previously it was not there. Law against female feticide was not there. The case Sehat, that is Center for Inquiry into Health and Allied Fields, versus Union of India, that is AIR 2003, Supreme Court 3309. There it was challenged that there should be some law, and Supreme Court directed government to implement law against female feticide. Law against female feticide with full determination. That means not half-heartedly, with full determination it should be implemented. Next, okay. Next is Nota case. Nota case, that is none of the above. Again, same PUCL versus Union of India. Union of India, that is 2013 10 Supreme Court cases 1, where there will be a nota button, that is none of the above button. Where voter will reject all candidates. If he is not happy with any candidate, he should have an option. That's what it was there. Okay. Next, convicted can't participate in election. So the question is Lily Thomas versus Union of India, where it was challenged that anybody who is having a criminal case in which he is convicted as a member, then he should not be able to stand in election for MP and MLA. And it was Supreme Court held that yes, if case if in a case a person standing as MP or MLA is convicted, he can't stand for election until such conviction is not set aside. Until such conviction is not set aside. Okay. So, okay. So almost we discussed many case laws and some more case laws we are to discuss. Also, I think we're left to 10, 12 case laws more. We will discuss them tomorrow. Okay, we'll also discuss the questions, the multiple choice questions that I told that we'll discuss. We'll also do that tomorrow along with certain other important case laws. Okay, these are not the only case laws because the simple reason is there are many case laws which we discussed while discussing the constitution itself. Okay, so those are also important. Certain case laws which I had not discussed, I discussed now. Okay, so those case laws which we discussed while discussing constitution, they are also of equal importance. Okay, any other case laws that are left? Because this particular important case is till 2020, I think, because recent thing, I have made another PDF, and we'll discuss those cases that is from 2020 to 25. We will discuss them tomorrow, and then also take up the multiple choice questions that are there. Okay, so thank you, and if there is no other doubt, we'll end this session and meet tomorrow. Okay, yes, Vishaka, tell me.
Sir,
Yes, Vishaka.
first data case mu chhadi ଦେଇଛି।
Yeah, sure. Showing it. First ହେଉଛି ଆମର Ayodhya dispute case. Take the screenshot. This is the first page. This is the this is the continuation of that case. And the second one is adultery decriminalized, that is Joseph Shine versus Union of India. So quickly recapping whatever we discussed: Ayodhya dispute case, adultery decriminalized case, and then Sabrimala temple case. Just from that, you will be able to recollect. Then 377 partly struck down case, live streaming of court proceedings case, Aadhaar bill and right to privacy, Puttuswamy case, right to die with dignity, common cause case, triple talaq, Saira Banu case, and then awaiting death cases, Ajay Kumar Pal, national anthem, Stamner and Chokski, collegium system, Supreme Court Evaluation versus Union of India, Sarla Mudgal, that is Uniform Civil Code, EWS quota, and then EWS quota, the case law, I did not tell you, no? I did not tell you the case law of EWS quota. Just write that. The case is, no, I don't have the proper citation of that. I'll just remind me tomorrow, I'll give you the proper citation. EWS quota. And then flag hoisting case, Union of India versus Nabin Jindal, change of words in national anthem, that is Sanjeev Bhatnagar, right to marry a person of one's choice, that is Hadia case, and then uh, highway liquor ban, then legal assistance, handcuffing, clean environment, Taj Mahal case, smoking case, right to education. Okay, then right to education, then sexual harassment of workplace, and then solitary confinement case, telephone tapping case, law against female feticide, and Nota case, and then convicted can't participate in election. That case. Okay. Yes. This EW quota case, you please write down. EWS quota case is, yes. The citation is, wait. Janhit ya Abhiyan versus Union of India. Yes. That's of 2022. Where it is, yes. Janhit Abhiyan versus Union of India 2022. Okay. Next, other cases we'll discuss tomorrow, and along with that, we'll also discuss the questions for prelims. Okay. Thank you all. I'll see you tomorrow.